Hello, and welcome to Higher Results, where business, workforce, and talent intersect. I'm Melody Reagan, CEO of Eye to Eye Workforce and your host. And today's show, we're going to cover privacy. Privacy has become one of those 21st century hot topics for employers and employees. And why? It actually affects everything. It affects when you are looking to hire. It affects how you treat and engage with your employees at work. It affects everything from drug testing through to social media. Can you monitor their emails? Can you monitor oral communications even? Can you put videos in your workplace from a monitoring perspective? Balancing security to privacy, all the way through to what information about an employee can you or can't you share? Can you give references? What happens from a healthcare perspective? There are so many things that we need to manage from a privacy perspective. And believe it or not, there are quite a few laws around this topic. I'm really thrilled to introduce our guest today, who is a very dear friend of mine, Liz Coker. She is the COO of 3P Health. And Liz, thank you so much for being here today.
Oh, thank you, Melody. I appreciate your asking me to join you.
Fantastic. Well, let's start off. You actually have some patents in privacy. So I would love for you to share a little bit with our audience today about you and your background.
Okay. Hi, I'm Liz Coker, as Melody mentioned, and I have a company called 3P Health. And our technology is based on 4 patents that Melody had mentioned, which is in the contextual data communication space. And that really has to do with how do we individualize the web for people. But in seeing all of the data that is required to individualize, we kind of had a holy cow moment, and we decided we needed to really look at how do we give consumers a choice in how they share that data and how that data is used. So that's primarily how our privacy patents got here. But that is not my background. I'm not a technologist per se. However, I do have a career in the technology space with 15 years in technology distribution, several years in product management with Hewlett-Packard, and I have spent the majority of my career helping startups to launch their businesses, their go-to-market strategies, their channel strategies. And then 12 years ago, my partners and I started 3P Mobile, which has since migrated into 3P Health with a focus in the healthcare space.
By the way, I love, though, it's like technology moving into privacy. Now, Let's start with, why is privacy such a hot topic and why is it important?
Well, all you have to do is watch the news every day. There is something going on as it relates to a data breach, Facebook, Twitter, etc. So in the world of digital privacy, everything is online all the time. It never goes away. So when you constantly are subject to permanent record of what you're doing, the issues related to privacy have a much greater impact than maybe they did in the past.
They seriously do. And one of the jokes that I always hear people say is, do I really have privacy anymore? Well, guess what? Yes, you do. All right, we're going to kind of jump in here. I want to jump into what are some laws. And just so you know, around privacy, quite a few of the laws are federal. And some of them that we're going to go through today, you will recognize. And we're going to start off with what everybody knows, the National Labor Relations Act, and what does it cover. Now, part of this with Liz, we've had fabulous discussions around this from a technological perspective as well as from a labor perspective. So what I'm going to do before I jump in, I want to share with everybody, what is the National Labor Relations Act? Well, here's what it very clearly states. Employers may not interfere with, restrain, or coerce employees in the exercise of their rights to engage in protected, concerted activities. And by the way, that is actually a legal phrase, and it is a legal phrase that relates to founding an association. So this is really what we tend to associate with unions. Mm-hmm. So what does this kind of cover, Liz?
Right. So the idea is that in a union, which has the opportunity to negotiate with management, they need a chance to develop their strategies, to kick ideas around before they come to the table with a specific approach that they want to take. And prior to that, right, that's messy. That's all the dirty laundry. That's all the bickering back and forth. So keeping that private until you're ready to come out with a common statement, a common face, is critically important to protecting the rights of your employees and union members.
Fantastic. By the way, I love that. And one of the things that a lot of people don't realize, and it may not just be unions, it's about coming together. Believe it or not, when it comes to it addresses things. What falls under this act, it can be everything from internet posts and putting parameters around whether you can share trade secrets or not. Mm-hmm. Believe it or not, the other thing that this actually does cover, and where when they're in associations, is what you can do from a surveillance perspective. You know, one of the things that a lot of businesses have is you might, and this is where technology is changing, you may want to put cameras around so that you are protecting your workers. Well, those same cameras actually can come back, and there can be rights from your workers' perspective of what you can and cannot see them doing. And we're going to come back and we're going to share a few things that you need to do regardless. There's some basic things that you can do, and it really is about common sense as far as addressing it. And what this very much says is that your workers have a right to come together and to share in their ideas for their own protection from their perspective and to come back to you. And it's something that you legally cannot get in the way of. So whether it's a union or not, you need to allow them to have that association. Anything else you want to say about this particular act?
I do think that the one other thing to remember, and we will see this as we go through our discussions, is that transparency, consent, disclosure will be key to making sure that you are achieving the goal, staying within the parameters of the law, and creating a healthy and productive workplace for people.
By the way, that's exactly to come back to. I love that you said that. It really is. If you're going to do something, it is unequivocally about making sure that you have awareness by your workers, putting it in policies, putting it in engagement letters. And the other thing that Liz says is there are certain things that unequivocally you have to have consent for. So at a very common sense level, make sure that you're maintaining awareness with your workforce and appropriately that you're getting their consent. All right, so we have another one that came up here. We're going to talk about the Electronic Communications Privacy Act, and I'm going to share with you what this covers. This is actually a federal law, and this governs the monitoring of electronic communications in the workplace by, this is really important, it prohibits intentional interception of employees' oral, wire, or electronic communications. So at a fundamental level, it prohibits us as employers from intercepting employees' oral, wire, and electronic communications. But there are some parameters under which we can do that. So what are some of the exceptions that we have for this?
Right. So clearly you need to conduct your business every day. So when you're sending official emails out to clients, you need to go back and review those emails, particularly if there's a question about terms of an agreement, something of that nature. Yeah. Of course, you need to have that ability to review them. But again, this comes back down to as long as your employees know,
common sense,
right? The consent and the transparency, that clarity is critically important.
So one of the things that we always encourage people, there's a balance between the rights of the worker and the sustainability of the business. You do have the right to monitor if it is for business purposes where you need to track things. And believe it or not, there are under certain situations where contracts are going back and forth in email that you unequivocally need to monitor that exchange and you need to file it. In fact, with my other company, Crazy Good Marketing, we have quite a few clients that we have to manage the filing of some of the emails just to maintain the contracts. But part of what Liz was saying as far as being straightforward with your workforce, you should be really clear with what you tell them that these tools are for business purposes. Make sure that you share with them that this is not for private use. You can share that you are monitoring their oral, written, and electronic communications. There are other situations under which that maybe you don't. You may state that this is very, very clearly the employers, this is my business computer, tools, etc. I have rights to all of those tools. Put them in your manuals, put them in your engagement letters. Be straightforward from a policy perspective. But there are other situations where you might be monitoring emails just because all of a sudden, and you need to work with HR on this, you are suspecting that there is an employee that might be embezzling or might be misappropriating certain resources of the firm. You have a right to step in and monitor that. But I would suggest to you that you bring in your HR team and you make sure that you are not going outside of bounds. Because if you're collecting data that you cannot use appropriately, then it's no good from the collection perspective. The other thing that you can do at all times, and this is something for you to think about when you're hiring, consent. If you get consent right up front, everybody knows at all times, whether you're doing it or not, you never run amok because you got consent right up front.
Yeah, there are a couple of things that companies are doing today from a technical perspective that help them to achieve these goals. So one, oftentimes, right, you have your personal email and you have your work email. And even though you might be receiving them through the same email client with your company, you know, your personal email is still your personal email. However, if time is being taken and all of that time is running through your personal email, well, that could be a red flag to your employer. The other thing is mobile.
That's right.
Right. So when it comes to mobile, some companies will issue company phones. And there are many people that walk around with two phones, one for personal use, one for private use. But companies such as VMware offer these virtual machines, these separate buckets on a phone, where the employer data, information, communications is held in one bucket. The personal information is held in a different bucket. And that keeps this separation of church and state much clearer for the HR and administrative functions.
By the way, I love that you brought that up from a technical perspective, because one of the things I always remind employers and employees, as a general rule, if the employer owns the communication system or device, guess what? They are generally free to monitor it. So it's your choice, too, as an employee. Keep it separate. Where you can, keep it separate if you really want it to be separate. So excellent point. All right, so the next one, and this is one that we've all heard a lot about, it is the Fair Credit Report Act, and let's dig into what does that mean. This is a law, and it's also federal. It regulates the use of consumer reports for employment purposes by employers. And this falls where we're talking about everything from background checks to reference checks, something that you want to pay attention to. For this particular act, it is really important that you get consent and that you are disclosing information. And it really does affect who you have doing what. One of the things that if you are considering something in a background check that is going to influence whether you're going to hire somebody or not,
right,
you unequivocally need to get their consent. You need to pay attention to it. And if that is a determination where you're telling someone, I'm not going to hire you for this very reason, you actually have to give them a period to check and make sure and validate that the information that you have received is accurate. And we all know, if you check your own credit reports, for example, one thing that we do with employers, we tell them if you're going to have somebody handling money, we do encourage you to do a credit check and a criminal check. You know, if you're going to have somebody in your business managing those two things, and believe it or not, we have run into some less than pleasant situations. We've also had some employers who actually come through and they work out a matrix on credit and how well that credit is for a person, because it says something, and it's really a tough dynamic.
Right.
But we have walked into situations where people have been charged with embezzling and a whole series of a couple of things that you need to pay attention to. But going back to, we all have credit reports,
right,
and they can be inaccurate. So
yes,
that's why you got to give them the period to make sure the information you're acting on is accurate.
Correct. So just one thing again, if you're drug testing a person, they know they're being drug tested. It's clear they have to go give a sample.
That's right.
This is no different. Think of it that way. It's just the same. Give them notification and give them time to validate that they haven't had something hijacked and somebody was setting up something in their name.
Yeah, and by the way, you cannot do a background check on someone without their permission. You technically do not have rights to that information. Doesn't mean that there aren't information sources, because I can tell you that they are,
Right.
that you use online, but technically you need to get their permission before you do that. And again, you have to give whatever applicant the period to make sure that the information you're acting on is valid. So, next one, you're going to laugh at this, but believe it or not, this really is an act that is out there. It's called the Employee Polygraph Protection Act. What does it cover?
Hook me up, Melody.
Believe it or not, you actually can do a polygraph. Isn't that crazy? It is true, and again, this comes back to getting consent. But believe it or not, for for government, federal, state, and local, it doesn't apply. They can do whatever at a government level. But this right here, you guys, you have to actually manage the situation, and you must give written notice to your workers for doing it. Kind of interesting, isn't it?
It's very interesting, and actually, I was not aware of that. So
Yeah.
on the federal government side, yes, but not on the
Yeah, it's all government.
Business side.
They totally got, and in fact, it's been in the news as of late where polygraphs have been coming up, right? Or is this person? And there are debates, if you choose to use this, there are serious debates around whether it is accurate or it is not accurate, so that you run into that. Just so you know, results of the test cannot be disclosed to anybody beyond the employer and the individual without their consent. And let's go back to always engage HR. And when it's past HR, get an attorney involved. It really is important. I love that you started with this awareness, consent. If right up front you have in your manuals that you're telling your employees about how you handle all things with regard to privacy, I can tell you it is better for you in the long run. Be open, be honest about it in the upfront. Doesn't mean that you have to tell them about every single situation. We've had employers that even though it's theirs, that all of a sudden they were sitting in a situation that they were suspecting that an employee had some bad contact. And they were forced to go and look at some of the records that they wouldn't otherwise do. And ironically, most employers do not monitor all of these things. It's an extra burden.
Right.
It's really expensive. So it's only when we actually need to. And the other thing is we do this when it matters for security.
Well, you bring up something that I'd like to talk about because there are many new laws that are on the books or that are in the works that bring up the issues that you mentioned right there. So within the United States, there are several laws that are coming into effect or that are already in effect that can impact what you're doing. So California has a new California privacy law. And that is the law that is probably the most strict within the U.S. and most similar to the European Union's General Data Protection Regulation, or GDPR, which some of you may have heard about. But there are very clear rights for, we're going to say, citizens, for consumers. This also relates to employees. So if you're holding any of that personal information, they have a right to know what information you're holding.
That's right.
They have a right to be notified should any of that information be subject to a data breach. And the amount of time that goes by between the breach and when that information is shared with the individuals affected is shortening. And in fact, Colorado has a new data privacy law that's coming into play after the first of the year. And you have 30 days between breach and notification, which is actually the shortest in the world. So Colorado is going to be the most strict on the data breach side. Then you have a place like Illinois, who has laws around biometric information. So think facial recognition. So if you're capturing data and you're not the TSA at the airport, and you're doing facial recognition, you may run afoul of the law, depending on what you do with that data and how you use it. When it comes to Illinois-based businesses. So it's a little confusing in the U.S. We don't have one global digital privacy regulation like they now have in Europe. There are things in the works to look at a standardized national regulation for the U.S., and many U.S. companies are just adopting the EU's GDPR standards because the cost to maintain two separate privacy
too much
approaches and policies is too much, time-wise, money-wise, etc. So unless your business is based off of collecting people's data, consumer data for purposes of marketing, selling, advertising, etc., we're seeing many companies just adopt the most restrictive privacy policies to simplify their administration. So one of those things to consider as you are looking at kind of moving into your next generation of privacy and digital privacy policy management.
By the way, I love that you brought that up. And just to remind everybody, we have national, but we also have state specific. So make sure, depending on where you're operating, it's not just about being headquartered. If you have a physical presence in California, it matters. So you got to pay attention to what are the state regulations. Now, I am really big on, there's a couple of other things I'm going to mention, but I'm really big on telling people what they can do to make it better. But before we do that, from an employment perspective, there are a few other privacy considerations. And this is one from an HR standpoint that is chronically kind of messed up when it comes to, it's unintended, but when it comes to your employee records, it's really important how you separate them. For example, your I-9s, and what your I-9s are all about is your identity and employment verification. If you're a U.S. citizen, I-9 should be filed separately. And one of the things that is really important for you as an employer, you need to maintain the privacy of your employees, their information, their email, their birth dates, their social security numbers. It is really important that you protect that information. If you're filing it electronically, you still have to keep appropriate things separate. And on top of that, you need to make sure that people cannot get to them. You need to have some layer of security around them, put them in different files, put them in, if they're physical, put them in a file that can be locked. Another one that people don't realize is the Americans with Disability Act. You know, when it comes to, and this is really a complexity from my perspective, you actually cannot share health information about your employees. And it's really one of those, like if you have somebody who's going out on surgery or whatever, as an employer, not your right to share it. You cannot share what they're going out for surgery on. You can just say that they're going to be out. Now, the worker themselves can choose to share that. But that's their choice. And I know we all love our workers. We want to support them. There's a reason different employers have actually gone away from birthdays and, you know, doing the support, et cetera. So it's really making sure that your workers know that, and it's their choice if they choose to share.
Yeah, and I'll take that back to the root of privacy. Privacy is contextual. Right? What I am willing to share with Melody on a one-on-one discussion might be very different than what I'd be willing to share with Melody as my employer.
Right.
Or Melody as my doctor. Or Melody as my child's teacher, right? So it always has to be put in context for your business, for your employees. When in doubt, get consent, make it an employee's choice when it is not something that you're sure whether or not you can share.
Fantastic. Well, I'm actually going to share with all of you, we have only just begun. We actually have a part 2 to this. We're going to dig a little more into medical, HIPAA, and then we're also going to talk a little bit more about the digital space, because this is such a rich area, and it is really, really important for you as an employer. Now, I always like to end on the note, what can you do as an employer? So here's one of the things that, what can you do to control this? Right up front, I'm just going to go back to clear communications, making sure that people know. Put your policies in your employee manual right up front. So every year, it's one of those, we have expectations. You update your employee manual. You make sure that your workers know what is going on. Make sure that within policies, if you can have consent, appropriately get that consent right up front. One of the things that I'm also going to say is, like we talked about for security, communicate within the security area. If you have cameras that are about, put this area is monitored. Communications and consent. Just remember, communications and consent. And that doesn't mean that you need to tell them every little thing at every single day. That's why we put it in our manuals. We have expectations and we put signs up. What are some other things you'd like to share that they can do?
Yeah, so there's some easy things. You can have a notice when people log in the morning.
Yeah.
Right? Just a reminder that, we monitor digital communications to protect our employees and customers. A reminder that employee information and customer information is private. It doesn't have to be a big deal. It's the consistency. When it's there every day, then you start building a culture that respects privacy.
By the way, the other one that you just said that's really important, and we'll be covering a little more in our part 2, is employees and clients. Client information privacy is equally as important. And making sure that you are filing things correctly and putting appropriate security around it matters. Well, Liz, I just want to say thank you for being with me today, and I'm going to look forward to you and I having part 2.
Nice. My pleasure. Thank you, Melody.
Fantastic. All right. So thank you for joining us today. We air every Tuesday at 3 p.m. Mountain Time on Facebook, and that's /higher results. If you miss a show, come and visit us at eye2eyeworkforce.com /higher-results. Until next Tuesday, we'll see you online.